First case for the morning is State v. Cunningham. Each party will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. Counsel, you know how long you'd like to reserve?
Good morning, Your Honor. I'm thinking about 5 minutes.
Okay. What will happen, we do have the clock there. You'll see it counting down from on the top. I won't change that at all, so when it gets to 5 minutes left, your rebuttal time's up on the top camera, and I'll also try to give you a warning for about a minute left, just in case.
Very well, thank you.
The arguments are being recorded. Now you can come on if you like. The arguments are being recorded. When you present your argument, please introduce yourself. Make sure that you stay there at the podium because it's being visually recorded, so we lose you if you go off, and also because it's being audibly recorded, please make sure you speak loud enough so we can hear you and the recording can as well. You should not use the name of any child, minor, or victim during the argument. If you do need to do that, please use initials or a term like the child was a victim, if you would. We read your briefs and are ready to proceed whenever you are.
Thank you very much. Good morning, Your Honors. Paul Meyer, representing the appellant. I think I can use his name, Anthony Cunningham. Mr. Cunningham's assignments of error are stated in the brief, but essentially we're suggesting that his convictions were not supported by sufficient evidence, and his verdicts were against the manifest weight of the evidence that was presented at trial. I did not try this case. So I did have a chance to review the transcript of proceedings and the docket journal entries, and that is how I'm posing my arguments based on that. One thing I think you're going to hear from the state's counsel this morning is that the conviction for grand theft, which was a 4th-degree felony, should be in fact, if that conviction stands, a 5th-degree felony. So I certainly would concur with that position.
How do you feel, counsel, about the remedy proposed by the state with respect to that?
All right, is the remedy for resentencing or?
Yes, that's my understanding.
Well, yes, it's a lesser charge with a lesser sanction, and accordingly, I think Mr. Cunningham should have the chance to be resentenced on everything. And I'm hoping that the court will also find some other items to present.
What does the verdict form say? Does it, they find the amount, but do they have the right level of offense?
You know, I'll have to defer to Mr. Whaley to respond to that. I'm not really sure about the verdict form. Again, I was not at the trial, and I did not inspect that form. I've heard about it. Essentially, our position is there was insufficient evidence to support these charges. I want to focus specifically on this aggravated robbery, the F1, the most serious charge, which has a 3-year firearm specification. Now, when I came up to the court today, I had to pass through a metal detector, and I do not have a firearm with me today. But if I were to come up to the bench and hand you a note and said, unless you reverse these convictions, I will shoot, I'm wondering, could I be charged with a firearm offense? Because I'm not brandishing a firearm. I don't have a firearm. And the state of Ohio would have to prove, if they charged me with some kind of firearm offense, that I actually had an operable firearm that was capable of shooting a bullet. Now, in Mr. Cunningham's case, he entered a bank building, no doubt about that. He walked through a metal detector on the way in and the way out of the bank. Nothing went off, no alarms. Okay? The teller that he spoke to and handed a note, yes, the note apparently said, I will shoot. However, he did not brandish a firearm. No firearm was seen. No firearm was ever presented in evidence. So we feel that to...
Is the record clear that the alarm did not go off, or that at least no one took any action as if the alarm had gone off?
Your Honor, I think there was some testimony from at least one bank person, maybe two. I know the teller spoke, and I think someone else from the bank spoke about the system that the bank used. I think it was the Fifth Third Bank. And as I understand the security at that location, there was a metal detector present in the entry the main entrance, nothing happened on that day, both at the time Mr. Cunningham entered and the time he left. So,
My recollection of the record was that it may be, that may be the case, and maybe nothing went on. Or maybe because the person was in what appeared to be law enforcement, they may have said, oh, they're law enforcement, they're coming in with a weapon and no problem. So it was unclear which of those two things happened. Whether the detector didn't go off, or whether it went off and everyone said, that's fine, they're law enforcement, we're not gonna make
well, again, I wasn't at the trial, but in reading through the TOP, I did not see any testimony about how he was waved in.
And that was what I just could not, from the extent we reviewed the transcript, I could not determine factually if the bank officials were sure A or B happened, or were not positive A or B happened. So your review is you're not entirely sure which of those two things happened.
I am sure that there was no alarm
Okay.
sounding either on the way in or the way out. And I would say to you, and I'm also sure that he did not brandish a weapon, and no weapon was ever found. And we don't know whether there was a weapon or whether it was operable and sufficient to support this firearm specification, and that's why we're suggesting that it should be reversed.
It sounds like the only evidence the state presented that there was a firearm is that he said, I'll shoot you, and patted his pocket.
What was the rest of that?
Patted his pocket.
He may have done that,
I noticed the state cites an 8th district case and a 3rd district case that stands for the proposition that an offender saying he has a gun and will shoot, that the trier of fact can infer both the existence and operability of a gun. I noticed there's not a 9th district case.
Right.
Do we have any contradictory 9th district cases? Or any on point in the 9th district?
I haven't seen any. I believe that the state did not prove that, I believe the state is required to prove the offender possessed a weapon that was capable of firing a projectile by means of an explosive or combustible propellant and was operable and could readily have been rendered operable at the time of defense. And that just wasn't done. Now, he may have patted his pocket, but again, I may pat my pocket and say, you better reverse this conviction or there's gonna be trouble, but I don't have a firearm and I shouldn't be convicted of a firearm specification. So, that's my point. So that's the firearm situation. I'd like you to take a good look at that, and then, let's see. Does that mean 8 minutes left or 8 minutes has gone by?
You have 3 minutes left in your initial argument.
Oh, okay, fine. Thank you. The breaking and entering charge, it is clear that Mr. Cunningham visited the office building where these offenses apparently occurred. He did, in fact, his former wife, I think, was employed in that building, and he visited her actually around the time that these thefts apparently occurred. But there is no evidence that it was Mr. Cunningham who surreptitiously entered the building. There was a breaking and entering. I just didn't see a lot of evidence that would support that charge either. So he was visiting his wife. There's no evidence that he actually, I don't think there was a video of him taking, I think there was some computer equipment or some other things that were missing from that building. And again, there's no connection between Mr. Cunningham and these missing items that I could see in the evidence. So I think at this point, I'll just defer the rest of my time.
Good morning, judges. My name is Rick Raley. I'm appearing today on behalf of Summit County Prosecutor Elliot Kolkovich in the state of Ohio, the appellee. As referenced, I'm here to ask you to affirm all of the convictions except for that F4 theft conviction. And I want to address that primarily because I think everything else has been pretty well briefed out for you. So at the beginning of trial, actually, the state requested the amendment of the indictment from that F4 to an F5 charge. And the verdict form includes a special finding that it was above $1,000. From that, I think it's pretty clear that everyone went forward. In fact, the arguments from counsel on appeal are about whether it satisfies the $1,000 threshold.
But does it have the level of offense on the verdict form as well?
It just has a special finding, which I believe is still.
No level.
Yes, that's what I understand. So I think that the remedy for that situation is that is modified to the lesser included offense of an F5, and that there is a remand for resentencing only on that count. So I would ask that this court comply with that.
How does the resentencing happen without a new conviction happening? Do you understand the question? I mean, you've got one document that said he was convicted of the M4. Now, how do we just change the sentencing without changing the entry?
So I think, I've read some cases in the past where it literally says you modify that conviction to an F5 from the Court of Appeals. You could just reverse and remand it with instructions that the court will modify it.
Could it be a non-proton since the verdict form has the right amount?
I wouldn't say it's a non-proton because there has to be a resentencing in this particular
A non-proton
circumstance.
of the,
Because there'd be a new sentence, and that's substantively different. I would point out on the firearm specification, I apologize for not citing the 9th District case on that point, Judge Lanzinger. I will point out that by statute, the state may rely on the offender's representations and actions during the offense to prove whether a firearm is operable. I think there's a well-settled status of law across the state that representations during an offense are enough to prove a firearm specification.
Counsel, I agree with you with respect to the first statement, which is to prove it's operable. But is there a wealth of law about to prove its presence?
I believe it's on there as well. I believe my citations go to that.
Okay.
And I think that that's something that's a matter of weight. These are all weight issues that are being raised, and they were raised in closing argument, they're being raised today, and the jury decided to reject that. Because by saying, I will shoot, that isn't but the defendant saying, I will shoot. That's a confession. And I mean, under our law, that's kind of the gold standard of evidence. And it shouldn't be something where we give basically an offender a bonus of, you got away so we couldn't get the gun. That would be the end result of adopting the defendant's position in this case. So for those reasons, judges, I'd ask you to.
so anytime someone says, I'll shoot you, we should have a firearm specification associated?
I believe that with that and with the actions that were present in the padding, that is enough for a jury to decide whether that is satisfying, yes.
Is there video of that? Because it's my understanding the padding of the pocket happened the first time he entered the bank, then he left, then he came back with the note. I'm trying to put the two together so we don't have any testimony as to one person at the bank that saw both of those things occur.
I can't remember explicitly right now what the teller's testimonies are about the padding. I do know surveillance video was put in. I don't think I pulled the word padded down out of thin air, but I do think that there's evidence of that.
Did anyone observe like a bulge or
Not
a
that
gun
much.
handle? Okay.
And do you recall that the question I asked was the record clear that the metal detector did not sound, or was it unclear that either it sounded or it didn't sound, and because the person was in law enforcement garb, they didn't concern themselves?
There was testimony on both points, I guess, as best response to that, Judge, as you saw. So I don't think it's really clear necessarily what happened with the metal detector, which is a further point of why we shouldn't latch onto that to say the convictions are against the manifest weight. I would say even if they didn't go off, I mean, common sense and common experience of people with metal detectors is they don't always go off. They're kind of there as security theater almost sometimes, unfortunately. And there is testimony that this person had something that looked like law enforcement, so he had the ability to override it. It wasn't a big deal to us. So I think all of that is a reason why you reject the manifest weight challenge. Thank you, judges.
And you have your full time for rebuttal.
All right, I'm just going to address the idea of the firearm specification conviction. I think that calls for a lot of speculation. We can speculate about the metal detectors, whether they were operating properly, whether they should have gone off when he went in, went out, and the fact that there was no testimony in the trial that they did go off. leads to certain inferences. There was no testimony that Mr. Cunningham or this person brandished a weapon. No one saw a weapon. I don't know about padding your pocket or your, whatever it was that you padded, whether that's enough to speculate that, well, he must have an operable firearm on him or he wouldn't have done that. I think we're going a little too far on our inferences. Again, the state should be able to prove that he had a firearm that was operable, and I believe in this case, that was not accomplished at the trial. So, and for that reason, we're suggesting and we're requesting that that conviction be reversed. I hope he is given the chance to be resentenced or remanded for further proceedings. And I want to thank you very much. That's all I have.
Thank you. The court will take the matter under advisement and issue a decision